Countries in the process of implementing a National Pollutant Release and Transfer Register, or PRTR, need to identify obligations and responsibilities of national institutions in charge of collecting, validating, and managing the register. Moreover, they have to deal with the accessibility of the data and confidentiality issues raised by reporting industries. This process requires national institutions to develop the most appropriate framework in which PRTR will operate, including regulation for collecting and registering the PRTR reports and ensuring that these data are publicly accessible. The first step is to conduct an infrastructure assessment of existing regulation or reporting requirements with regards to emission of pollutants and hazardous waste generation that are already enforced at the national level. The regulatory gap analysis will help national authorities to include PRTR provisions under existing legislation. This approach provides an opportunity to consolidate or rationalize existing reporting requirements, thereby reducing the reporting burden and administrative costs for both industry and government. If the legal environmental requirements or monitoring system for industries are lacking, governments can draft a new PRTR legislation after consultation with all key national stakeholders, for example, ministries, national authorities, industries representatives, NGOs, and academia. The National PRTR proposal is a document which usually contains all the features of the PRTR system to be implemented. Designation of the national authority responsible for PRTR data management, the list of substances and hazardous chemicals to be reported, thresholds that will trigger reporting to the national authority, voluntary or mandatory reporting and identification of a compliance system, rules on confidentiality claims, option for disseminating PRTR data. The decision whether to make PRTR reporting mandatory or voluntary should be taken by governments during the early design phase of the register. The two systems are not mutually exclusive and can be implemented together. Voluntary PRTR system will require some form of agreement among reporters and governments. For example, on the types of releases and transfer covered, frequency of reporting, as well as the means and format for reporting. The same concept can be applied to mandatory PRTR systems, except that in this case, the government can apply appropriate enforcement measures to operators, as well as to officials responsible for reporting that are acting fraudulently or negligently. In addition, PRTRs with a mandatory reporting system can deal consistently with non-reporters or partial reporters, and can handle confidentiality claims more equitably in comparison with a voluntary reporting system. For this reason, the majority of PRTR involve mandatory requirements, which tend to provide more consistent and valid reported data. To enforce reporting obligation, a compliance mechanism can be established to prevent failure to report, delayed submission of reports, reporting incomplete data, reporting inconsistent or miscalculated data. Compliance mechanisms may also take the form of compliance promotion, compliance monitoring, or enforcement. Countries may consider providing incentives to encourage facilities to report to a PRTR. These incentives may support solutions to overcome a lack of knowledge or capacity. Compliance monitoring can be used to detect non-compliance through instruments such as inspections, audits, off-site record reviews, and regular meetings between inspectors and operators to discuss existing and potential compliance issues. Countries may also consider issuing penalties for non-compliance, resulting in enforcement measures or administrative sanctions. In order to avoid confidentiality claims or to avoid missing information in the reports, affected or interested parties should participate in recommending how confidentiality information is handled according to the goals of the national PRTR. clear guidance concerning thresholds, definitions, units of reporting, frequency of reports, and conditions for claiming some data is confidential must be provided in advance to reporter. In most cases, the national authorities should interpret the grounds for confidentiality in a restrictive way and should weigh the public interest served by disclosure against the interest served by confidentiality. However, the decision to keep data confidential is taken by the competent authority, in accordance with the PRTR regulations included in the national proposal, or national laws that already classify how confidential business information have to be handled. While one ministry will likely hold the overall responsibility for setting up the relevant structures, many ministries are likely to be involved for the collection and management of relevant data, including the Ministry of Environment, Agriculture, Energy, Labor, Health, and Transport. In such cases, structures for interministerial coordination will be needed to redefine or enforce already existing monitoring and control tasks, as well as to unify the methodology used for collecting and validating the data, in order to achieve a functional database. The lack of legal and institutional frameworks, together with the existence of non-compatible data collection obligation, and thus different non-compatible databases maintained by different national institutions, will result in difficulties in PRTR development and implementation. Thanks for watching the modules on legal implementation of PRTRs. To learn more, please visit UNITAR PRTR platform.